you confirm that you're still under oath? Say I do.
I do.
Dr. Young, just you had dealt with the historical bad blood that was alleged. I think you have dealt with that comprehensively, I think. But just one little point regarding perhaps the manner in which you left UEC project. Were there any difficulties that would have resulted in the need for mediation between you or you personally and UEC projects when you left? And this is a matter you address at paragraph 7 or 8 of your statement.
Okay, so there are two different points here, which fortunately you're mixing up. The mediation to which you refer has got nothing to do with UEC projects. It's to do with my involvement in the project with people from ADS. So they're actually two different points. There's the antagonism issue as well as the mediation issue, but they're two different points.
But the antagonism issue is a matter that you have dealt with, I think, comprehensively. Yes,
but again, without belaboring the point, and I'm just now talking from memory and not try to keep it short, is, and I reread the witness statement early this morning. In fact, I was going to work from that rather than my own evidence, but of course that would have taken longer. But Admiral Carman says that there were so many... okay, I need to go one point. The reason why there's a little bit of confusion here, as I've said, is this advocate Sabia actually drafted this stuff. I tried to fix it up as far as possible, but there's not proper continuity between point to point. So I can now understand why there's this mix-up. So I need to address them both. But what is meant in the context of mediation is when I was working on the project for C squared R squared in these technical committee meetings and a design advisory committee meeting to which Admiral Carman refers in his evidence, that there were many heated situations where they would have to stop the meeting, and I suppose that's being himself and maybe the project engineer, Egan Fowler or Fritz Norkier, used to take us outside or take me outside. I'm afraid to say it is completely 100,0% untrue. It never happened on one single occasion, not one. I'm sorry, I'm not getting upset. I just have to emphasize it because it's so crazy to actually make that statement under oath. And of course, it's said in disparaging terms. It's said specifically to cast me in a bad light. It just didn't happen. In fact, I can only remember 2 occasions in that whole project where other people got upset. One was in a design advisory committee where a guy called Don Van Zyl, a very excitable man, made something, banged the table very hard, and another meeting involved somebody called John Ritchie and Lewis Matheson, where Carman was not involved at all, and Lewis Matheson threw John Ritchie out of the meeting on a point of order. But in all my years, that's the only time I actually saw something happen. The other point I wanted to make is that surely, if this had been an ongoing thing, that either I would have been thrown off the project, or somebody would have written a letter to me, somebody like Pierre Meyring or Admiral Howell or something. But it's completely bald, the statement, you know. There's no record of it in minutes of a meeting that we had a break for 5 minutes while Young and whoever got a bucket of cold water thrown over them to cool them down. It's just complete rubbish nonsense. I'm sorry.
Right. Perhaps one other aspect that you have dealt with in quite extensively relates to the relationship between your company and BAE Simmer with regard to the IMS. You have indicated in your evidence already that you were invited to work with BAE Simmer. You recall that?
Yes, but sorry to interrupt you, but there were 2 points. There's the mediation point as well as the antagonism point, and that's an important one. I do need to clear that up. You're correct when you say that the BAE Simmer ASM issue has started. If you don't mind, keep my train of thought and what's in front of me, if we can just deal with the antagonism point.
Okay.
Okay, I certainly take the points made by the chairperson seriously, but this particular point of antagonism also is a so-called historic bad blood, possibly ends in why I left there, and where he says that I left under a cloud or something. I'm afraid that is not only bald. I don't even think it's from his own knowledge, because he's obviously forgotten who I was between 91 and 93, where he met me again. But be that as it may, as I've said, without in my evidence here, without traversing every point in detail, I was the longest serving member, Cape Town branch member at this particular stage. When I joined Trivets UEC, it was as a project engineer in 1985. That in itself was a promotion from my previous job. I had 3 promotions in that, well, what he calls a short time. It was certainly 7 years is not that short, from project engineer to project manager to departmental manager. And as I've said, in the very end, in fact, I was interviewed just before I went overseas to give my presentation to RENA. In fact, while I was overseas, the decision was actually made, and I was only overseas for, I think, a week or so. It wasn't long. But I don't think that if there had been bad blood, that was, according to Carmen's evidence, it was known that I had started my own company. I've acknowledged, in fact, in the Project Public Protector hearings, I acknowledged that I registered a company, but as I've stated under oath, I never earned 1 brass cent or even did probably 1 minute's work, if that, until the 3rd of February 1992. So unfortunately, it's an incorrect statement. But if one looks at the logic of it, first of all, it's illogical that in terms of my promotions, and as I've said here, is I think every single year I got a salary increase and a performance bonus. In fact, I think I got, I said, I promoted 3 times, and I received 12 salary increases in 7 years, and each was accompanied by, in words of recommendation signed by the same, very same Mr. Howells and his boss, who was known to Admiral Common, Mr. Johannes Bear. I think I do need to point out what's written in my paragraph 607, where Johannes Bear says in his letter of 1990, which is not that long before I left, he says, "Dear Richard, the Cape Town branch, of which I was almost a founder member, has performed well during the past year, despite major setbacks brought about by cuts in the defence budget. I am very aware of the fact that such successful levels of performance can be attributed to the number, or to the efforts of a number of key people. It is group policy to award performance bonuses, not a matter of course, but recognition of exceptional contributions made by individuals to the company's team effort." I don't need to go further than that. But by 1990, as far as I can remember, I had registered that company. I hadn't told anybody about it. because I don't think I needed to tell anybody that I'd registered a company that that reserved a particular name of C squared R squared systems. I didn't operate it. I didn't work on it. I didn't earn any money. I didn't earn any tax returns or pay VAT or whatever. So as he goes on to say that the company found out about this, and that is why I left under a cloud. Okay, that's nonsensical. But what he also says in evidence, if it's not here, to the public protector hearings, is that, now listen to the logic of this, just to show the nonsensicalness of this, is that he says that the ADS Thompson legal team will be able to ascertain the existence of my company because it only took him a couple of minutes to search, now that we're talking about 2001, to search on the registry of companies for the existence of my company. Now think of that. What if they knew that I had a company of which I was working for and earning money, and that caused problems before I resigned in 91, in January 92? Why did the legal team need to go and search for the company registration details? I'm afraid to say I have done a formal course in logic at UCT after I did my PhD, but I'm afraid it is not a cogent argument. In fact, it is complete and utter nonsense. This is patent nonsense that is designed to affect my credibility. And Admiral Commons representative here, Advocate Cooper, talked about reputational damage. That's a polite way of exactly the reasoning why this evidence has been given to this forum.
Now let's get back to the BAE SEMA matter that I had just introduced before you responded. In the evidence of Admiral Kammerman, there is a discussion relating to your relationship with BAE SEMA and the consequences that relationship would have had to the South African industry had BAE SEMA and your company been appointed to offer the complete solution regarding the combat suite. Now, that discussion appears in the transcript. Perhaps it starts. Perhaps the relevant portions thereof starts at page 6399 of the transcript. Your word system document is 6215. If you go to your 6216 and our 6400 for the record, and starting at line 13, there is this whole discussion about the South African combat suite, and your name is mentioned there. There is a passage that reads, "There is no doubt at all that British Aerospace or BAE SEMA got wind of that when they themselves would have gone to the Reutex and the Greentex and the Denels to explore cooperation on this alternative combat system, and they were obviously given short strip. The secondary, of course, is that BAE SEMA probably found out in the intervening weeks that they were dealing with a company of 20 people that had no factory, that could not post performance warranties and guarantees in a major international competition at all, and that certainly would have, let's say, caused them to withdraw. Just briefly, what is your comment to that?
Well, it's all patent nonsense. It's fact, it's the biggest rubbish I've ever heard in my life. Having been involved on the inside of this process, I can say that I say that from insider knowledge. Of course, Admiral Karmerman knew something of what is going on, specifically because we briefed him on that. But even in that context, he doesn't tell the truth. But to try to give the impression to these proceedings that this idea of BAE SEMA pitching in a competitive way against Thomson 80 is just completely that they got the idea from us and that we led this is just untrue in every single respect that one can think of. First of all, as I testified a day or two ago, this is something that they had been interested in for years and years. In fact, I can tell you that I didn't realize the significance when I gave my RENA presentation in December 91. A person was there. I didn't realize the significance of it, but he came to ask me a question. His name was Chris Courteau. He was the same person who was at SA Navy 75 in 1997, and the person, one of two, who requested Arms Corps to provide them with documentation about the IMS. But BAE SEMA had been looking at this opportunity for half a dozen years. And as one truthful thing that Admiral Karmerman says is the 20-man company wagging in fact, BAE, British Aerospace, is a bigger company than even Thomson. I think it's got 300,000 people. So anyway, it wasn't my idea. I don't intend to traverse every single aspect of the documentary evidence, but there is documentary evidence, which I'm not sure whether it's included here in my witness statement, but there's a documentary trail from way back when, at least 97, where they were not only in contact with our company, but other companies. In fact, there's one letter I can remember signed by somebody well known in our industry called Eddie Noble, who was a manager of the electronic warfare company, I think Grenica Electronics at that stage, but going back, way back when, in the 97-90, of communications between British Aerospace and them, asking whether they were interested in being involved. And that's just one piece of documentation that I have. But anyway, I do know from my personal involvement, every single company, from Reutech to Grenica to Denel, and smaller companies like ours, were canvassed for their interest. Of course, the only company that they didn't canvass was ADS, because by this stage ADS was being taken over by Thomson, who was their competitor. Okay, that's one part of it. The other contention to make, that it was British Aerospace who pulled out of the country because the negativity that I had generated with my so-called colleagues in the industry then bit me back, is just completely untrue. The reason is, as I've stated in the one letter written, I think, by Alan Nicholson Florence of BAE, or no, it might have been Richard Southwell. But anyway, it was because of the competitive situation. It's nothing whatsoever to do with C squared, R squared. I have to pause there, but I'm not finished on this point.
Is there anything you want to add? I need to take you to another passage regarding this BAE SEMA matter.
I'd certainly welcome you to take me to the right passage before I develop verbal diarrhea.
Now, there is a passage at our page 6402 of the transcript, and it's your page 6218. That passage starts as from line 14 during the discussion of this relationship between your company and BAE SEMA. There's a proposition put to Admiral Kammerman by the chairman where he makes the following point. Let me just get some clarity from the witness. Will I be right to say if Dr. Young had succeeded with his plans as contained in the letter that is referred to in that during the course of that discussion, the entire local industry, as far as the combat suite is concerned, would have been compromised? And Admiral Kammerman responds, Commissioners, yes. Not in the final analysis of work that would have been given to some of those South African contractors, but in the main, the entire combat suite was affected in every instance, particularly the ADS instance that he was proposing to completely displace ADS, a 450 South African manned company for the integration work and the combat management system with a completely British-owned and British-staffed company. The work would have been done in Britain by Britons with British technology. Would you like to comment on that?
Well, other than almost every single line of that is a lie, I seldom use that word in proceedings like that, but that's the only appropriate word, because even on the version of the presentation that was given to him, as RC alludes, what he states on the 16th of December, which is correct. I know it because it was a public holiday, because that's the day that he asked that the presentation be given. It was the only day that he was available. But in that presentation, as well as I think the letter to which he refers, my letter to him, but certainly in the presentation of which I have, not in the last day or two, is British Aerospace were proposing an organization called ASM, Advanced Systems Management. In fact, the original incarnation of ASM was not by me. I never started that at all. I was only invited to join because I had a thing called the IMS, which would have been the glue of this combat system that they were proposing, and the combat management system in particular. But be that as it may, ASM was not registered as a PTY limited company, but as the presentation said, is that it was proposed to be a completely South African solution, other than the technology insertion or technology injection of British Aerospace's, or BAE SEMA in particular's, combat management system and its technology. But of course, although they wanted to supply that system, there are a couple of important points. First of all, they wanted the IMS because that was part of the baseline. They wanted the same architecture, they wanted the same technology, they wanted every single aspect of it as met the naval user requirement specification, as the user requirement specification, the program plans, platform requirement specifications. All of those baselines they wanted to retain. The only thing that they wanted to do was, now that there was a competitive situation where ADS, let's say ADS Thompson themselves, were taking out the indigenous Project Diamant, Project Caliban, AIS, and WC-based combat management system, to replace it with the French version. All that BAE wanted to do was to say, well, instead of a French technology here, you cannot be preordained if this is now in divergence from at least the then baseline of which is documented in the element costing and description. All we want to do is compete on an even footing with that. And if one also has sight of, and I certainly would like to do it, but I don't think it's necessary because I'm under oath here, so I'm hopefully telling the truth. I'm doing it at least as best as far as my memory is concerned, is that all the documentation that is provided externally to the Navy in terms of the presentation is provided externally to the GFC in terms of exactly, precisely the same presentation I think was given just before. And we, being me as part of ASM with British Aerospace at this stage, had given that presentation. I think the only difference is that it says vielen Dank at the end of it rather than thank you. That's German for thank you. So everybody was aware of what the intentions were. Indeed, those same presentations and the documentation to which Admiral Karmerman had access show beyond any doubt whatsoever that the intentions were to include every single aspect of the South African local combat suite. Every single part, except, of course, not the AIS and the WCU, which at this stage have actually been kind of rejected by ADS themselves, but the BAE part. So, I think that covers that particular point. But I was actually looking at something on the previous page on my 6217, if I may address that point.
That would be our 6401. What line would that be?
Second line, it said very suddenly withdrew.
Oh, the passage you're referring to is at our 6400, just about line 23. Young makes the fact, he makes a direct implication that no British Aerospace very, very suddenly withdrew. Is that the passage?
Yes, that is true. And
yes, you can do that.
First of all, it's very true that they suddenly that they extricated themselves within like 48 hours. The letter that I've put before the Commission proves that. It was a huge surprise and disappointment to us. And of course, it is very, very suspicious of their own on-the-record statement, which of all of their directors, senior directors, saying this is a must-win project. Anyway, Admiral Carman states here at the next line, we found it absolutely wrong, but I think means wrong to use that word, that he would have concocted an alternative combat suite that would have displaced thousands of South Africans behind the backs of the local industry that he'd been working with very closely for the previous 7, 8, 9 years. And the consequences of that was that he was certainly cold-shouldered by industry thereafter. That's the first point I wanted to make. Now, it's just complete nonsense, because I was a very small part. I was only invited to participate in a smallish way. Of course, it was a small part involving some equity because they wanted our buy-in, partly maybe in terms of risk. But they were working all of the levels, every single thing you can think of in the industry, in the Joint Standing Committee on Defence, in the Navy, in Arms Corps, you name it, they were working. They had nothing. In fact, a lot of the stuff only got to my knowledge, which it did, but after the fact. They were calling the shots. Had nothing whatsoever to do with me. And certainly, unless Admiral Coleman knows something that I don't, I was never cold-shouldered by the industry, because there was first of all, there's no reason to do so. So, you know, my small company is surviving here 16 years later. Right now, we're pitching for Project Hotel, the hydrographic survey vessel, and Project Barrow, the patrol vessels. I'm certainly not seeing any evidence now, as there never has been, ever once, of any cold shouldering by the local industry, for the simple reason that it's just not true. Of course, at the end of this particular point is something extremely, extremely interesting, for me at least from a legitimacy of, or the illegitimacy of my interest in being involved, and the legitimacy of making, of clearly as his own evidence states, of discouraging this competition. Maybe I need to read the rest of the sentence. It didn't in any way affect our intention to include it in our baseline, which we did. And ADS apparently took a more mature view of the fact that they had been challenged, but it came to naught, and British BAE SEMA would have no chance in the competition in any event. Now that is fraught. It's absolutely fraught statement. Okay, the baseline thing was, of course, the IMS. As we can see, even at this stage, even though the involvement with IMS didn't upset the correct acquisition authorities enough to remove us from the baseline. That was removed through completely different reasons. But it's not actually quite true that ADS apparently took a more mature view. They just took a very sneaky view. As their own letter said, they would carry on engaging with us but without any real intent. But anyway, what is more important, it did come to naught. But as he says here, BAE SEMA would have had no chance in the competition in any event. Now, if I may say, how can somebody, in terms of MODAC, in terms of the constitutional imperative of competitiveness, how can it be, in terms of the Arms Corps position put into writing by the CEO of Arms Corps, okay, certainly after this, of asking the GFC to which was their instruction to look for alternative sources of supply. That can only mean competition. There's no other interpretation whatsoever. So that clearly somebody would have been in a position to make sure that BAE SEMA, and specifically a South African version of an organization, of another consortium, including BAE SEMA and Telemet, had no chance. That is a fairly serious statement to make.
Now, if one has regard to your comments to the passages I have referred to, plus the evidence you have already tendered to the Commission with regard to your relationship with BAE SEMA and its participation in the bid for the combat suite, would it be fair to say that concludes your evidence with regard to the aspect of BAE SEMA and the evidence tendered by Admiral Kammerman before the Commission?
There are other things, but I think I have at least addressed sufficient of them to at least demonstrate that he's not always correct of what he has said to this Commission and previous other similar type of bodies. Unfortunately, his evidence, I think, is the witness statement is 108 pages, supported by 785 pages of evidence documents and 299 pages of witness statement. Much of it applies to me personally. My intention, as I've said, I don't intend to address every single one of these aspects, just sufficient enough to show that Admiral Kammerman's evidence cannot be believed, certainly not in all instances. I think I have read in the transcripts of this Commission the reference, and I think I also remember the letter that my former evidence leaders, Advocate Skinner, SC, and Admiral Sabia wrote to this Commission regarding the view of Admiral Kammerman's evidence. And I've seen it referred to as stubborn evidence. Okay, I think I have said sufficient to negate the view that it can be viewed as stubborn. certainly not where it affects me in any way, or any of my evidence regarding any of the points. But there, of course, there is just one other point that you skipped over, and that also involves a extremely important point. It was brought up a couple of days of reputational damage. If I may just find, we skipped over it, if I may just search backwards for a particular search term, which I will do while I switch off this microphone.
Advocate Berg, are we still busy giving evidence then? Well, I see the witness is checking something else.
Yes, there is a reference or search he's doing with regard to the last point he says he wants to make in his evidence, yes.
No, just that I heard him saying that I must search, so I wasn't quite sure whether he's still going to give evidence or not.
Yes, he is giving evidence, Chair.
Thank you.
Sorry about that. We've been skipping various points here, and I lost my train here. I have found both the point in my witness statement. It is my point 711, where I say it is defamatory for Carmen to suggest that I had, in my own words, stolen Brown or ADS's intellectual property. And I also refer that in his own evidence, the transcript of it. It's in my page 6176. Sorry.
That would be in the transcript, page 6360. I perhaps before you deal with that, I should just remind you that I think a couple of days ago, you did give evidence with regard to intellectual property that was alleged to have been stolen.
Yes, thank you very much for that reminder. That was in the context of when just after I left UEC projects and started C squared I squared, and on an ethical basis I traversed with the company. I think we referred to the letter from the personnel director, in fact he was, Trevor Moore, the whole issue of intellectual property and copyright, and I think that letter, as well as my analysis of it, certainly the evidence was that there was no such intellectual property. And if I may say, I left UEC projects in 1992. That is 24 years ago, and never once in any form whatsoever, whether it's been loose talk in the gents or at meetings or whatever, certainly not in emails or formally lawyers' letters, has there ever been the slightest bit of inference that I had done anything involving copyright or ADS's intellectual property. So I was quite interested to read this. It's a pretty serious statement that sits here in front of us. Certainly if it was accepted and I wasn't to rebut it, it would certainly be damaging to my reputation certainly as a professional engineer. Anyway, at the relevant point, Rear Admiral Kharma is recorded saying is he had problems overall with ADS, because when he had worked at ADS, he established his company and started it in a secret way. And then he had a major blowout as a result of that with the management of ADS, particularly Mr. Duncan Howells, who was still the senior manager responsible during these negotiations several years later, as well as individuals such as Mr. Doug Law Brown. spelt with an E, who was a fellow engineering manager with him when these things were happening. Some of Brown's technologies were utilized, comma, let's say, for commercial means. Now, of course, this might go into the hallowed ground of interpretation, but I cannot come to any other interpretation, is that this difficulty that he is reporting with me could have ended up with me stealing Doug Law Brown's technologies, intellectual property, or whatever it is. Now, it's just so bizarre, because first of all, it didn't happen, and secondly, as a manager there, as he says himself, Doug Law Brown would not own any technologies if he was a manager for UEC projects or ADS, Altec Defence Systems or African Defence Systems. So such a statement, not only is it bald, is, in not such gentle terms, is highly defamatory.
Is there any other passage you want to refer us to here?
No, I think this is sufficient for the present purposes.
During the course of your, perhaps before I ask the question, is there any other aspect of Admiral Kammerman that you want to deal with before we close off on that aspect of your evidence? And I have one more aspect I need to canvass with you.
I'd be very pleased if you took me to one more aspect.
During the course of your testimony yesterday, you made reference to a Captain Reed in a Section 28 interview during the course of the JIT. You recall that?
Yes, I did. I need to state that that is a very important point, and thank you for bringing back, but it's not necessarily, well, it's not at all in the context of my response to Admiral Kammerman's evidence. It's a self-standing point that I brought up under the theme of irregular decisions made in the submarine acquisition.
Yes, I thought my understanding with you was there is nothing further that you wish to raise with regard to the evidence of Admiral Kammerman. That's why I went to that point. Is there any other point that you want to traverse with regard to the evidence of Admiral Kammerman before we get to that point?
Quite happy to go on to that point you've just mentioned. Just like a break while I close down a couple of the documents here before it's never happened before, but I wouldn't like it to happen right now.
Please indicate once you've finished closing the documents you're dealing with.
Advocate Sibeko, shouldn't we perhaps try and help the witness, because I'm sure we don't have much time. I see he's going through doing some research here. I thought he was coming to give evidence.
Chair, the witness indicated that he's shutting down some documents. He's not looking for anything so that he can deal with the issue that I had asked him about. He's not looking for a document.
He's not looking for...
He's shutting down.
Yes, of course, I think we referred to this document yesterday. It's a statement under oath, Section 28, interview of Captain Reed. It's a document that was only provided to me probably today, 3 weeks minus 1 day ago. I didn't have a digital copy myself. I was downloading this at the beginning of our work here today, and that's why I've got a digital copy in front of me. But we did ask Advocate Madumbi to make 21 copies, including one for me, which I haven't seen yet. That was why I was opening up my digital copy, in addition to closing down the documents. But that was what I was looking for, including the relevant sections, so I can go straight to them.
What is the relevant section of the document that you're downloading?
Sorry, may I ask, have all the relevant parties got their documents?
I don't think the relevant parties have got all the documents. The file has just been furnished to us a short while ago. But I'm sure we'll make copies available to them. Just point us to the relevant part.
Okay, well that just means me that I need to put the document into context. I think I've just done that partially. I've only got 3 points to make here. It'll only take 3 or 4 minutes. But I'm looking at page 2105 of the transcript, and this was provided to me by the Commission, as I said. So hopefully that means it's on the record. And I am looking at a scanned version of the document, which I'd like to read out, so I won't make any mistakes. I'm looking at, looks like the beginning of line 25.
Sorry, Chair. We're having some difficulty in identifying the evidence or the document to which this witness now seeks to refer. And it would be of great help to us if we had something a little more detailed by way of reference than we have at the moment.
Thank you, Mr. Cooper. The document that the witness is referring to is entitled Investigating Directorate Serious Economic Offences Inquiry in Respect of SANDF, held at the Brooklyn offices, Pretoria, inquiry number 1/4/3, 21/2000, date 2001, 0806. Witness, Mr. A.J.C. Reed. Chairperson, Mr. C. de Chemont, Office of Auditor General. Examiners, Mr. K. Pether, Office of the Auditor General. Mr. M. Tsiki, Office of Auditor General. On behalf of the witness, Ms. C. Dreyer, State Attorney. Mr. A. Ramji, State Attorney. And the witness is referring to you said page number 2104. Is that correct?
Thank you.
Yes.
What line did you say you were referring to?
I'm referring to what looks like it's line 30 at the end, so it looks like about line 25, starting with the word we realized at that stage.
You say it's page 2104.
I think I said page 2105.
Right, you say at line 25. It starts with, we realized at that stage that it was going to be a government decision.
Yes. I think that's important in its own light with regarding my contentions regarding the formal acquisition procedure, but I say here, quoting Admiral Reid, who is the project officer of the submarine, and I'm giving this evidence with respect to the theme of my evidence, which says allegations of corruption, conventional submarines. I'm not necessarily saying that this is a direct indication of corruption, but it's certainly an indicator of the process. Going back to my document, he says that we realized at that stage that it was going to be a government decision which submarine was going to be purchased, and we wanted to make sure that there was a wide range that would be acceptable to the South African Navy. Now, of course, this is a back-to-front acquisition procedure in terms of MODAC. But be that as it may, I now come to my next point. That's an introduction point to the point I want to make on that page 2114.
What line?
Starts at line 11 and ends at line 19. Okay, it says, what, comma, the whole risk report came about at a meeting in Simonstown, where I felt that the team was not pulling in one direction, full stop. Decisions, comma, certain decisions had already been made about, firstly, which submarine we were going to get, comma, which combat system we were going to be getting, and people were, on the team, were still pulling sideways. So at the meeting, I tried to encourage everybody to live with the decisions that had already been made, and if they did not like those decisions, then to let us know about it. I suppose it's unnecessary for me to analyze the meaning of those words.
But you say these passages must be read in the context of your statement, where you deal with allegations of corruption with regard to submarines.
Yeah, well, that's just a theme. I deal with allegations of corruption, but of course I deal with the selection process, which is an allied theme. In this particular point I wanted to make regards to the legitimacy or otherwise of the decision for the submarine and the process, which was clearly the one that happened, not in my words, but in terms of the project officer's words. I still want to come to just one sentence, but I'll pause there for the moment.
Is that sentence on the same page?
No, it's on I think it's on the next page, 2115. At line, it also looks like a line about line 15.
Yes.
Okay, it's not as I'm trying to cherry pick. I'm trying to give a context, including a chronological context, because this whole thing is about decisions and about risk reports and process. And Captain Reid says here, because this was still early in the process, comma, it was before the final offers were on the table. Hopefully that my inferences are correct there. But the point I'm trying to make is that the decisions had already been made. So if I may say so, why bother to go out to a competitive acquisition process and waste all of those companies' time when the decision to select the submarine had already been made?
Now, having dealt with all these aspects, this would bring a conclusion to the sub-theme you had started to deal with yesterday when we had to look for this transcript. Is that right?
Yes, that's correct. I think that was actually indicated to me by my legal team, my evidence leaders. So, yes, it was done. And I know why. It's because this document actually came to me so late, and we only addressed it in paper form. And I'm glad I think that's one of the what the evidence leaders do is they lead the witnesses' evidence.
Chair and Commissioner Musi will ensure that copies of the relevant pages of this transcript, and perhaps the entire transcript, just to give the context, is copied and given to the various legal teams. And perhaps it would be placed at the end of the last annexure in file 7, I think, for purposes of administration. And perhaps just to complete this other aspect, there was an annexure RMY 139. It's a Thompson-McConey letter that you were going to look for. Did you find it?
Yes, I did indeed. The PDF version is in front of me. I was just searching for the relevant section in my witness statement, if I may.
You will provide a copy of the document so that it can go into the bundle, so it can accord with what you have quoted in your statement. Is that correct?
Correct.
And that, for purposes of the record, will be marked RMY 139A. That document is dealt with at your paragraph 7. Let's see. Yes, 692. Having dealt with these aspects of your testimony, I think that would bring us to the concluding paragraphs of your statement. Is that correct?
I hadn't quite got there yet, but if you want to take me to the correct number of my statement.
What paragraph do you say? 6-1? What paragraph number are you talking to?
So I've lost my place, but I can find it quite quickly.
We had been dealing with the paragraphs at, perhaps if you go to paragraph 184 of your statement, there are paragraphs there, 7, 10, going forward. The issue relating to the allegations relating to the theft of Brown's or ADS's intellectual property is dealt with at paragraph 711 of your statement.
Yes, that's correct.
You have dealt with that, I believe, extensively. At 7:15, you say it is. Well, you say you also did not have input into Feinstein's submission. It seems there was an allegation that, or a statement made by him, or evidence given by him, that you contributed to a submission prepared by Andrew Feinstein.
Yes, I certainly had no input. In fact, I didn't even have any visibility of it. I think I've only met him 3 times in my life. Once was after this commission had been promulgated, but quite a long time ago. Once was, I think about 5 years ago, where he sent me a couple of sensitive book to proofread, but otherwise I haven't had any interaction with him in this regard.
Now, Dr. Young, having read through your 7 paragraph 723 going forward. It does appear, as the chairman has pointed out, that the paragraphs contained herein have been dealt with quite extensively in your evidence in the last 6-7 days. Do you agree?
So I think that's a fair statement to make.
In fact, going right up to paragraph 751, which deals with the revolving door issue, it does seem we have covered most of that quite extensively.
Yes, I think I would agree with that. I think I just want to point out one thing that we haven't discussed regarding the theme of my response to Carmen's evidence right now anyway, is the issue of my attendance at RENA in 91. I just wanted to point out that there was nothing untowards about this. There was nothing untowards whatsoever about doing it in my company's name, and this was all done with the full knowledge of Arms Corps and the relevant Navy people at the time, and there's documentary evidence to show that. But I agree. I'm just putting in this the theme of this, the context of this particular theme.
And that part of your evidence you have dealt with and have referred the Commission to RMY 3 in File 1. Do you recall that? The slide presentation that you made at that symposium is a document you have included in the documents. Perhaps putting the question differently. There appears to be a registration form. It's your document 0003 and our RMY 140 with regard to what appears at paragraph 743 of your statement. RMY 140 is at 2908. Yes, it's at file 6 continued. Have you found that document, Dr. Young? 6 continued. Could you please identify the document for the record?
Yes, it's a document signed by me. It is an application form, or registration form for NAVTech 91, Royal Institute of Naval Architects International Conference on Information Technology and Warships. Identify myself as an author at this stage, all to do with the fact that I could get free entry instead of paying £450 sterling, and I identify the applicant for registration as myself, and the company as CCII Systems with the relevant address at that stage.
And in the following paragraphs, you demonstrate, as you have previously in your evidence, that there was nothing untoward in you attending this symposium or conference, and AMSCO was aware of that. In fact, it seems it was at AMSCO's instigation that you did.
was actually the project officer of Project Frizzle, which was the combat suite part of Project Falcon at that stage, Commander Brian Blackbeard. It was his instigation. His opposing part was Anton Jordan of Arms Corps, who reported to Pierre Maring. As far as I know, Pierre Maring was fully in the loop here, but there's certainly documentation from Anton Jordan that gives me permission to do so, and there's documentation from me to him of explaining the reason why it's the presentations in terms of a dummy company, because as he says himself, that I may not indicate the company I work for, UEC Projects in those days. If I may say, at this stage, when I prepared the presentation, did the application for registration, I had absolutely no idea that I would be leaving UEC Projects. Basically, well, my application form, I think, was it August? This one's not dated, but you can see it was as early as August of this year, and I was leaving. I left at the end of January. So the Navy was involved, Arms Corps was involved, my company management were involved because they approved my airfare and my foreign exchange, etc. I'm pretty sure, I can't quite remember this, but I'm pretty sure that if not this very page in front of us, or even a synopsis of my paper, would have been attached to my overseas, my application for overseas travel.
And with all of that would really bring us to the conclusions section of your statement, right? Having gone through those paragraphs, 752, perhaps right up to 774, that really is a summary of what you have set out in the statement.
Yes, if I may. So maybe instead of me not having my own legal team, and instead of me finding a legal team quickly, or even submitting my own argument in terms of submissions, maybe this can be dealt with not now, but is in lieu of those kind of submissions and argument.
At your paragraph 775, with its sub-paragraphs, you suggest what recommendations should be made by the Commission after it has had all the evidence, and that would be something perhaps that could be dealt with at the appropriate time. Is that correct?
That's correct, yes.
That then would bring us to page 198 of your statement, and that is the signature page of that statement. Would you agree?
Yes, I have a signature page. It might not be the same page number because I've been adding in things to this it's a working document, but I do have a signature there with my full and correct name for the purpose of the transcript as well, and the date on which I completed and signed this document.
Is there anything else you wish to add to the statement or your evidence that you've given up to this far?
Possibly only by means of extra information that I don't need to address now. I have added on an Appendix A, which is a recordal of what was published in the ANC today in year 2003, 30th of May. I think it's fairly apt for, just as a title for this, for these proceedings. The author, Thabo Mbeki, who was the president at the time, says our country needs facts, not groundless allegations. I'm not going to ventilate this at all, other than to say this was a response to me done in digital form, I have responded in terms of my blue text here. You might not see it. Unfortunately, it was not printed in different colors, but certainly my version has got paragraphs written by the author, and then my responses. I did this in a little bit of a hurry, so I didn't maybe use the right inverted commas and indents and whatever else is. But be that as it may, I'd be very happy if a colour copy were made to the parties who were interested in it. But the other point I wanted to make is this has been a tough ask for me, but if I'm responding to what the title says of our country needs facts and not groundless allegations, I would certainly hope that what I've certainly tried to do is provide facts, mainly documented facts. As I set out right from the beginning, as I told my evidence leaders who are helping me prepare this, as I preferred to base the facts and the documents, not on my documents. Of course, there are my documents where they are particularly relevant, but on other people's documents. Sure, when it comes to the nitty-gritty, unfortunately, I'm not party to any corruption or irregularities. And of course, the question may be begged, if I was, would I be telling the whole truth and nothing but the truth and supplying evidence thereof? I think that deals with that particular point. It's a couple of pages because it was a long digital epistle. But my Appendix B was just a placeholder, because if time permitted, I did want to address some of the evidence that was given at a fairly late stage, at least by Chippy Sheikh. I think his evidence was given in November, which was just when I was beginning to prepare my witness statement. And Fana Hlongwane, I've mentioned his name. I will be open and frank as I possibly am allowed in terms of the protection of my sources, which unfortunately for me is, unfortunate in a way, is more important than anything else. Sources who give one information and swear me with the recipient to secrecy regarding the disclosure, that has to take precedence over anything else. But be that as it may, where I provide evidence, I'll provide evidence in documentary to form and not my own hearsay. But there is something that I could add on there. There were just 3 other people whose evidence I've looked at, and I wanted to make some fairly short observations on it. And that is, I think, Gerard Grobler from Arms Corps, Rear Admiral Philip Schultz from the Navy, and very shortly, in the context of that, Rear Admiral Higgs. I'm fairly exhausted. If I don't get the opportunity to do so, it's not going to kill me. In fact, doing so might kill me. But if people ask me to address this, then there does seem to be enough time to catch even my 6 o'clock flight tonight. But I'm quite happy to spend some of the time doing what I can, and mainly, unfortunately, from memory.
Dr. Young, I think I'm going to have a difficulty of allowing you to give evidence without having provided us with a statement. You knew all along that you're supposed to be coming today, and one would have expected that you would have prepared the necessary statements. I'm going to have serious difficulties of allowing you to try and testify about issues that you haven't given us a statement on.
Would you wish to respond to that?
There is, unfortunately, the place where I live, at least, it's called reality. There was no ways that I could produce this comprehensive witness statement in the 2,000 hours or so that it's taken me over the last couple of years to prepare it, with all its complex references to the source documents, which I have been doing for a considerable period of time. And of course, if I may say, it was not, and I need to put this on the record, it was not incumbent upon me to prepare my own witness statement. In 2013, in June, I got a letter which I put onto the record via means of my submission that the Commission communicated to me via its leader of research, Advocate Mdumbi, that indeed the Commission was working on my evidence statement. And I'll say that my previous evidence leaders, Advocate Skinner and Advocate Sabia, insisted that they do they did my witness statement, that I would, in legal terms, settle. Of course, settle before I signed it as my own. That only changed on the 25th of November last year when I was visited.
Dr. Young, I'm going to make a ruling. I'm not going to allow you to make such long speeches which are not going to help us. If you want me to, in order to meet you halfway, what I'm prepared to do is that you must prepare a very short statement about the issues that you want to traverse, and let us have that statement by next week, Wednesday, and then when you come back for cross-examination, first thing in the morning, we can quickly deal with those things with those issues before the cross-examination starts. Will that be good enough?
I think that's a very fair media via media, and I'll certainly endeavour to do so.
That is my suggestion, unless if you're told there's anybody who has an objection to that.
None from us, Mr. Chair.
No objection, Mr. Chair. No objection.
Thank you.
No objection from us either.
Thank you. Then, Dr. Young, can we have a very short statement, whatever you want to prepare relating to those issues that you say you still want to traverse? And we are going to adjourn. We'll come back on the, let's see, which is the date. On the 23rd of March, and we'll reserve about 5 days for you, so you will have enough time to deal with those few remaining issues. Let's see here, we'll be dealing with you from the 23rd to the 27th of March 2015. So what we'll do that morning is that in the morning we'll deal with a few issues that you want to deal with, and then from there we'll then start with the cross-examination.
Thank you for that. I think I may say, if I certainly prepare the statements, that I don't think we'll need more than an hour, maybe 2 at max. So we should have the better part of 5 days to complete my evidence in total.
Thank you. Then, secondly, this venue is not going to be available on the 23rd. Apparently, there's going to be a council meeting during that week, and we have made alternative arrangements. The alternative arrangements are that we are going to sit at St. Children Council Chambers, which is at Conarabi and Cantonment Streets in Littleton. They say just opposite Unitas Hospital in St. Julian. And on that day we'll start at 9 o'clock. And I'm sure we'll all try and make sure that, we take the right routes. We don't have complications about accidents and traffic. As Commissioner Moses is saying, we must all try and avoid accidents. Then 2, we are coming back next week on the 16th. We are supposed to be sitting on the 16th. From the 16th to the 20th. And I see, are you in a position to help us with that, Advocate Sibeka?
Chairperson, I am not. I believe that Advocate Mdumbe has been making some arrangements with the evidence leaders who are scheduled to be commencing with the evidence of the manufacturers. Perhaps he might be the right person to speak to in this regard.
Chairperson and Commissioner Musi, our next witness will be a representative of ThyssenKrupp Marine Systems. He's scheduled to give evidence on Monday. Details with regard to the other witnesses will be communicated to interested parties on Monday.
So what we are certain about is that ThyssenKrupp will be testifying
On Monday,
on Monday.
yes.
And the venue is still the same venue. We're not going to St. Children. Same venue. We'll only be going to St. Children from the 23rd. Dr. Young, will I be right to say that we'll see you on the 23rd in St. Children?
A very long way to go. So, it's 300 kilometers the other side of Cape Town. So I'd say only, mainly in jest, but it is quite an effort to get here, and I certainly hope that nothing goes wrong on the way, but it is certainly my intention of doing so.
You say you'll be traveling 300 kilometers from wherever you're staying to the airport?
That's correct, and much of that is on a dirt road as well. So I say it's quite a mission to get here.
And from what I've gathered, there are very few accidents in that area, so you're likely not to miss your flight.
Yes, but all the accidents there actually seem to end in people's deaths. So there are quite a few actually, not as many small bumper-to-bumper accidents like in Gauteng. We have the serious thing down there.
Thank you. Thank you. Thank you. We'll adjourn until Monday.